Good morning to everybody. I think you must be tired by now. As a former lousy, law school student, I have full sympathy for you. After 4 full classes of legal arguments filled with legal gobbledygook, I mean, what can I say? Galaxy ago, I aspired to be a great lawyer, but I ended up being in the foreign service, half-baked expert on international law, and a lot of whining and dining in diplomatic circle doubt my legal mind. So please bear with me. I try to be a bridge, between laymen and these 4 great lawyers. And first, let me start with a bit of, common man's observation. Maybe 3 or 4 points first. First, on the Philippines. I think many of us in this room would agree that the Philippine legal team did a hell of a job, a really remarkable job in terms of bringing about this landmark decision as described by Professor Schofield. Specifically, they skirted around. They avoided the issue of 2 issues, sovereignty, and second, maritime delimitation. And not only, they became, a great winner, but their behavior after the ruling, I think, merits some attention. No euphoria, no salt rubbing into the wounds of the counterpart, very, very measured. That's what I found when I went to Manila after the ruling. So yesterday, our Filipino colleagues was, expressing his loneliness. But I can tell you that you are not walking alone. So you did a really great job. I wouldn't call it ambush, contrary to the expression expressed by my Chinese colleague, Professor Bin Lin, because that seems to be the only result left to the Philippine government after bilateral dealings. Second point is on China. Well, Professor Bin Lin said their decision on non-appearance was disastrous. I agree, but what was more noteworthy was the reaction after the ruling. Well, you would say it was expected, but yet disappointing. Chinese foreign minister called this arbitration farce. Arbitration ruling waste paper. Even he called a respected Japanese judge named Mr. Yanai, who had to pick up arbitration judges just because China refused to do so. They called this Japanese judge right-wing hawk. So what kind of willingness to abide by the international ruling, that is in question. You might say their reaction has been ill-advised. It was too much. I will leave it to the judgment of other people. But usually, losing and winning is, regular thing. If you lose, many countries would take it as a way of graceful exit from policies bound by domestic constraints. And it seems that China is now losing that opportunity. The third point is the expectation of the international community. Yes, award is legally binding upon the parties, as has been explained by Mr. Tan's paper. There is no question about it. And it seems to have certain effect. Professor Bin Lin wrote in his article that China seems to have avoided asserting the ambiguous dotted line since the announcement of the merit award. He described could be obituary, but it's still remains to be seen, and as I said, China is facing difficulties in respecting this international ruling. My fourth final point before I pose 3 questions to panelists is this point of caution. Because whenever we call on our Chinese colleagues to abide by this ruling, they make counter-argument. How come the United States, which is not yet a party or signatory to UNCLOS, can tell us to abide by the provision of UNCLOS? I would say we need to take this kind of argument with a pinch of salt. Of course, it's better for US to become a signatory to UNCLOS, but US has taken the provisions of UNCLOS as customary international law, and as far as we know, there is no outright violations of the provisions as far as the United States is concerned. And the matter is on China. I mean, we are now talking about the case between the Philippines and China. So this, discussion of bringing, U.S. into the ring seems to be a deliberate, attempt to try to, shift the attention of the international community. Our Chinese colleagues, would say, what about Japan? You will have difficulties in respecting this ruling because you have an Okinotori Island. My argument is, legally speaking, this ruling is binding only upon the parties to this dispute, namely the Philippines and China. But are we going to ignore it? No, of course not. It's going to be respected. But as has been pointed out by some experts today, there are some points of controversy. For example, what do we mean by a stable community of people? Are we not going to have any island? If there is no inhabitants on that feature, are they not going to be entitled to 200 nautical miles? I think that is a big question, which needs to be continuously examined. And we have to wait and see accumulation of precedents. And we often ask this question to Chinese. If you are so unhappy with the ruling, and if you have so much grievances about the legal status of Okinotori, are you guys willing to bring the case to ITROS, arbitration court? Before you do so, you have to first accept this ruling. Then, our colleagues in Beijing become speechless. So, I mean, we have a lot to ponder on this case. Finally, in the interest of time, I would like to pose 3 sets of questions to experts. Question number 1 is, Professor Bin Lim pointed out, China has exercised regular participation in WTO dispute settlement process. Yes, I agree with that. So why this difference between the trade and investment regime and political security arena? China has been a beneficiary of the WTO free trading system, but China has also been a beneficiary of freedom of navigation, freedom of overflight. So why does China pick and choose international rules? That is question number 1. Question number 2 is, based upon the expectation of us, international community, what can we do in terms of prodding China to respect and abide by the international rule? We have issued a lot of diplomatic statements, G7, ASEAN, ASEAN plus 3, ARF. And, Professor Bin Lim also pointed out in his paper that the reaction from the international community and other claimant states would go a long way in bringing about compliance in the long term. So if so, what specifically can and should we do? That is my second question. Finally, question number 3 is, what is left to us to do in pursuing legal venues? Is this the end of the story as far as lawyers are concerned? Dr. Tam pointed out there are some issues left unanswered. So, if so, what can we do? COC is the answer. Bringing the issue to UNGA, UN General Assembly, is an answer. Or is there any other legal method to pursue? It seems underlying issue of the South China Sea is conflicting territorial sovereignty claims. If that is the case, can we or can they do something? That is my last question. Thank you.
Thank you, Ambassador, and thank you to all the speakers for some very interesting presentations. In the interest of time, perhaps we can take some questions from the floor, and then the speakers can respond to Ambassador's questions and also from the floor. Thank you.
Thank you. Two questions. First, suppose that Vietnam, Malaysia, and Indonesia have settled their EEZ boundary in the South China Sea, and they decided to jointly submit this to the UN and proclaim them. And in response, China protested to this submission in the similar manner that it protested. It had protested Malaysia, Vietnam joint submission. So how could this affect or impact the agreement should the three countries agree to? My second question relates to the traditional fishing grounds. So China claims some part of Indonesia's EEZ as its traditional fishing grounds. Suppose that the China's claim of fishing ground is separate from the 9-dash line. How legally justifiable is China to pursue this claim? And how can the two countries approach this issue? Because I am reminded of Australia-Indonesia agreement on the MOU box, and what if, say, China wishes to pursue this approach? Thank you.
Isao from Japanese Embassy. I have a question about the status of the China in the confidence building measures, for example, the fishery arrangement or environment preservation arrangement. This is a question as a layman, and United States and to some extent Japan as well insisted that territorial claims should be based on the land features. And this arbitration denies the historic rights claim of China over particularly the Spratly Islands. And I think that sooner or later, the ASEAN countries or claimants start talking about the confidence building measures, for example, fishery arrangement. This is very important project. And in this negotiation, how can we treat China? What do you think of the legal status of China? China should be considered as a legitimate claimers or illegitimate claimers when it comes to particularly the Spratly Islands. I think that when we treat China as a legitimate claimers and overall we treat China as illegitimate claimers, that makes a difference of the treatment of China in this negotiation. So what do you think of the China's status in this in the future confidence building measures arrangement? This is my question.
And we'll take a second round of questions in a moment, but just one last for this round from Professor.
Thank you, Chris. I have a question for Professor Bing-Ling. We have some conservation, we have discussion with Chinese scholars, and they explained to us that the decision not to take part in the arbitration is basically and merely on the legal aspect of that. The advisor to the government was telling that China cannot win the case, so the decision not to take part is to avoid the loss of image of face in the international community. So can you enlighten us on this kind of explanation? Thank you.
I think if I may, then I'll comment briefly, if I may, particularly on the issue of historic rights and historic title in the South China Sea, which was at the core of your question. I think that the tribunal's decision is quite useful in this regard because it maps out the difference between historic rights and historic title in the context of the 9-dash line. But what it doesn't, and it essentially suggests that China has claimed a variety of different historic rights, but not historic title as such, and that reasoning comes from the case between Norway and the United Kingdom in terms of how to historic title being concerned with areas that are exceptionally enclosed within baselines. And that is distinct from the situation in the South China Sea, where you have a broad, discontinuous 9-dash line, and yet China claims straight baselines around the paracels within which it has internal waters, and therefore historic title is essentially claimed in that kind of context, where there are internal waters within, but there is no historic title claim to the entirety of the area within the 9-dash line in the tribunal's perspective. So that is quite a useful way to distinguish between these different between historic rights and title, and that is one of the areas where the tribunal has, in a sense, completed some unfinished business that it wasn't covered within the Law of the Sea Convention. What I would say is that China's rights within the 9-dash line aren't entirely extinguished, because in the context of Scarborough Shoal, the tribunal finds that multiple states have traditionally fished within Scarborough Shoal, including China. The decision of the tribunal is that China is in breach of the convention by denying Filipino fishermen access to Scarborough Shoal's waters, and therefore denying Filipino fishermen their traditional fishing rights. But the tribunal is silent on whether China itself has traditional fishing rights within Scarborough Shoal, but implicitly the tribunal having stated that multiple states have traditionally fished within Scarborough Shoal, then one would anticipate that China also would have traditional fishing rights within Scarborough Shoal. So that suggests that China's fishing rights and historic rights are to some extent preserved within the 9-dash line, within the context of Scarborough Shoal particularly. On the comment around Malaysia, Vietnam and the Philippines, I think it was, having reached a maritime delimitation amongst themselves in the South China Sea and then deposited limits with the coordinates and charts with the UN Secretary General, Division of Ocean Affairs and Law of the Sea at the UN. What would be the impact of that? It would be a declaration, in a sense, to all marine users and other states, but one would anticipate immediate protest from other states, and that certainly has occurred in the past for other delimitation agreements.
Yes. Thank you. Thank you. Let me address two questions that I think directly relates to my presentation. The first is is Yamagami-san's first question. The question regarding the why China acted or behaved differently in the WTO dispute settlement setting and in the UNCLOS setting. I think there are multiple reasons. For one thing, the WTO dispute settlement has teeth. It has enforcement mechanism. It will be most unwise, and even China can see that, not to participate or not to appear in the WTO dispute settlement setting. The other thing, more importantly, I think especially in the minds of the Chinese, South China Sea is viewed as the so-called core interest. It's just too important to be left to some foreign judges to decide. Whereas WTO, well, it's trade, it's commerce, it's business. You may lose some money out of it, you may lose some face out of it, but it's tolerable. The second question that I would like to address relates to the question that's raised by the gentleman over there about why China did not, what were the reasons behind China's decision of non-appearance? The reason that you cited, which is that China considered that it will lose in this case. This is a common excuse that's been putting forward around. I think it's part of the calculus, but if that is truly the prime reason for China's non-appearance, then it's deeply flawed. Well, first of all, we all know that if you participate, you don't necessarily win, but you don't necessarily lose. I think China's legal arguments on the jurisdictional questions, this is, I think, observed by many international lawyers, China's case on jurisdiction is much stronger than its case on the merits. And if you do take your South China Sea, your 9-dash line or dotted line to heart, if you do think it is your core national interest, then you do your best to prevent this core interest from being exposed to international judicial scrutiny, which means you have to participate at least in the jurisdictional phase of the case. And the other thing is, if you participate, you get to appoint one judge, and you probably, you can negotiate about the 3 other arbitrators, and you probably can get another judge who will be sympathetic to you. So you get 2 judges already on the panel. So a decision of 3-2, supposing China lose, a decision of 3-2 is still much better than a unanimous award. And the other important thing, if China does participate, there are a whole suite of litigation tactics that China can employ. You can try to slow down the process. You can try to delay the proceedings until the Philippines had a new election. You can try to use all kinds of pressure on the Philippines, the old administration, the new administration, to try to force a settlement. You don't have to, I mean, the case doesn't have to be decided. But the thing is, you have to participate. If you don't participate, chances are you are going to lose. It's not a guarantee that you're going to lose, but you probably will lose. The last thing about the dotted line or the historical plan. I know lawyers are bad at maths, but it's still remarkable that people talk about 9-dash line when clearly there are 10. There are 10 dashes. There's another dash up in the north, outside Taiwan. So when you consider the legal character of these dotted lines, oh, by the way, the Chinese official name for these lines is dotted line, not U-shaped line or 9-dash line. So the dot, you have to consider the dotted line as a whole, and the Chinese and the Taiwanese international lawyers have discussed this over many years, and the Chinese have been pressuring Taiwan to disclose the archives behind the nationalist government's drawing of the line back in 1947. And I don't think the Taiwanese government had assisted China that much. I think the plain truth is, when you think about 1947, at that time, the international overseas only has, well, territorial sovereignty and territorial sea, and that's it. So any line drawn at that time must only have that implication, not the kind of EEZ or continental shelf or even more expensive historical rights. Thank you very much.
I don't know if there's any specific question addressed to me, but I just want to touch on several issues. The first one is about, I understand that you asked about the possible submission, joint submission of extended continental shelf to the UN by several coastal states in the region, and what will happen, whether there's any possibility that China will object to such a submission in a similar way to the objection China lodged against the joint submission by Vietnam and Malaysia. And this is a very interesting question. And I did address this in a presentation a long time ago. The basis for China objection is the annex to the rules procedure of the Commission. In that rules procedure, it says that if there is a dispute, then the Commission will decline considering the submission. But and I argue that whether there is a dispute is not the task of the Commission, because Commission is a group of technical experts, not a group of lawyers. And the question of dispute is a legal question. And whether there is a dispute in the South China Sea must be necessarily determined by a group of lawyers. And I argue that if a court by the tribunal decides that the NADASHA has no validity, that there's no entitlement to exclusive economic and control shell generated from the islands, there could be no disputes in the South China Sea any longer. And thus I argue that the Commission necessarily consider the submission by the coastal states, because that you cannot simply accept that China's make a declaration, then it can constitute a dispute. Then one day China will make a declaration to the Arctic and say that, yeah, we have a claim here, and then you cannot submit any external commercial submission there. So I think that there must be some legal consideration, and it is not the task of the Commission. So I hope that I address your issue. The second one is the traditional fishing ground, and I think that there are possible grounds for China to argue that. The first one is, and China did allude to that, in the case of archipelagic states. It was protected under the convention, and the tribunal expressly recognized that traditional fishing rights are protected in the archipelagic waters. But the issue is that you need to negotiate with the archipelagic state on the regime how to regulate that traditional fishing rights. So China needs to specify its rights and enter into negotiation, rather than it unilaterally impose its rights or so-called rights upon other states. The second one is traditional fishing rights in the territorial sea. And that is not the rights of the states, which is different from historic rights. But that is acquired rights of national, of fishermen. And I think that the tribunal has a lot of human rights experts in this, in their composition, and say that the acquired rights of the fishermen need to be protected, and that is protected by general international law. And because the state exercise their sovereignty in the territorial sea in accordance with the convention and general international law, it need to, the coastal state need to respect the acquired rights of the fishermen. And I think that it's up to China now to specify where there can be traditional fishing rights in the territorial sea. And I think that, and as I argue in the paper, that there's plausible traditional fishing right in the territorial sea of the spar sail and the spartleys. But now you have to recognize it, and you also have to recognize other states also have those rights. And so it's up to China. And I agree with Professor Bingling that China has more to do if they resort to international law rather than to resort to force. If they have a lot of, we often call in arbitration that guerrilla tactics in arbitration. You have a lot of tactics to argue, to delay, to attack the tribunal, or to delay the process, rather than just boycott the arbitration. It's not a tactic. Of course, it's a strategy in litigation, but it's not a tactic, really. So for the, I don't know whether I should address the question by the commentator or we reserve for the. Okay, I guess.
I'll keep it. I'll keep it brief, as I know there are other questions. I'll address very briefly the Ambassador's third question. What else can we do in law? And I just sort of make the point that in the international system, as much as the national system, the question what you do with the litigation outcome is usually not best answered with more litigation. Right? You know, we negotiate in the shadow of the law. We don't go back to court endlessly or look to proliferate the dispute in other legal fora more than necessary. But I would agree with Professor Nguyen that there's a very interesting point about the UN Commission on the Limits of the Continental Shelf. A joint submission to that commission would trigger an interesting practical point in that historically it has refused to deal with submissions if there is any hint of a dispute with another state. And where in effect you've had an independent arbitral tribunal say there is no basis for the dispute, would it take in effect notice of that or not? It's an interesting point. Finally, in terms of how should China be dealt with in fisheries arrangements in the region and confidence building measures, I'd just say that in a sense it should be treated, I would have thought, as having a legitimate seat at the table if one looks at Article 123 of the Convention. It's a semi-enclosed sea, it's a coastal state. Even if you take you know, the award at its highest, there's going to be a kind of a large high seas donut hole where everyone will be able to fish. And the approach encouraged by Article 123 is to say, you know, you have a common marine environment and a common biological and ecological set of conditions, and when you're facing depleting fish stocks, you need to come together to come to solutions, and that's about those ecological facts rather than questions of where does your jurisdiction end.
Thank you. We had two other questions I saw. I might just take the two I saw from before, so Professor Shirley Scott and Bob Lowry.
Thank you. I'd like to thank all the speakers. I thought they were excellent presentations and I have lots of questions, but maybe I'll ask just one of Professor Schofield. If the detail of the award has implications that other states may not like for other parts of the world, do you think that will temper the impact of the positive impact of the award in terms of helping the situation in the South China Sea?
And Bob?
One to our legal geographer. Should we be referring to the Spratly Islands or the Spratlys Rockery? More seriously, just a hypothetical to draw out some of the legal aspects. If you look at the Philippines EEZ, it's clear that the court said that Mischief Reef at Second Thomas are low tide elevations, but China has built an air base on one of them. The question of the Scarborough Shoal, in terms of sovereignty, has been left open. So it is, at least in theory, possible, after some sort of discussions or arbitration, that it could become a Chinese bastion within the Philippines EEZ. I'd imagine you can clarify that. But from a diplomatic point of view, looking from the Philippines' perspective, would it be possible for them to recognise political reality and say, look, you know, the Chinese are not going to pack up on Mischief Reef, but let's come to an agreement whereby they give up any claim to sovereignty over Scarborough Shoal in exchange?
And can we have a 1-minute response?
Okay, very good. Thanks, Chris. Thank you for those questions. For Shirley's question, in terms of the unwelcome aspects of the award for coastal states, which may feel in particular a threat to the broad maritime jurisdictions they claim from isolated insular features, I would expect that many states will focus on the idea that this award is really only binding on the parties, nothing to do with us, and there will be a strong pushback from states, a great reluctance to actually pull back or roll back claims. And I can only think of one instance globally where a state has unilaterally decided that on reflection a particular feature that it generated 200 miles from, and this is Rockall in the UK, is in fact not a fully fledged island capable of a broad 200-mile claim, but is only a rock, and rolled back the limit to its fishery zone at the time, and lost, I think, of the order of 50,000 square kilometres of maritime jurisdiction in the process. And that is the sole example of a state doing so. And it's difficult to imagine that foreign ministries will be keen on the idea of rolling back existing claims from states. I think there'll be strong pushback. But where I think there might well be influence of this award is not about delimitation, but I would be very hesitant in taking a case for maritime delimitation to any international court or tribunal where one of the base points or any of the base points on my side of the line are small, isolated, insular features. I think the reasoning of the tribunal may well have an impact on that type of case into the future. On the question of the Spratley's rockery, I do like that. It has gardening overtones, which may suggest habitability, which goes against the award. I think it's easier to know a rock when you see one in certain instances, and I did have some imagery of what Scarborough Shoal looks like, and a gentleman clambering onto a feature. The highest point on Scarborough Shoal, or Scarborough Reef if you prefer, is 3 meters above high water and is roughly the size of this table. So I think it's demonstrably a rock, and the tribunal, it's difficult to challenge the tribunal's reasoning on that, in which case the maximum is a 12-mile territorial sea that would sit within the Philippines EEZ. I find it somewhat doubtful that we can have a tit-for-tat exchange in a negotiation between China and the Philippines regarding Mischief Reef and its status, but that is non-legal and purely political.
Did anyone else have a further 30-second comment? Okay, well, I think we all agree that this session, as with all the sessions, has been very informative. The issue of law is, as has been highlighted, important. Each of the speakers has done an excellent job in covering their own unique set of issues and provided their own unique perspective. I think I can assure Ambassador Shingo Yamagami that your legal mind has not been dulled through the foreign affairs days, and so thank you for your very useful insights over the papers and talks. Maybe I'll just finish with a kind of rhetorical question that can be picked up perhaps at the workshop, and your question as well during the workshop later on, and that is just that the idea that there is such a debate and perhaps a degree of clever manoeuvring, in or over international law. This links to what Clive just mentioned with regard to, say, Scarborough Shoal. I think we just have to caution against. I mean, I may not be an international lawyer, but reading UNCLOS and the idea of what it details could be reasonably considered to be an island or not, there weren't too many surprises beyond Itu Aba in terms of what could really reasonably be debated. And so what follows from that is, how surprised could any of us really be? And could anyone really sit there and basically not be aware that perhaps certain claims are not in line with international law? So I hope we can maybe talk about that at the workshop, and perhaps also pick up on the idea that now, for example, that the Philippines has a clear EEZ, can it maybe call on assistance to protect its resources, etc.? Are there other sort of secondary effects and secondary stages in terms of bringing greater clarity and maintaining these EEZs as a consequence of the ruling of international law? But thank you very much. We're a bit late for morning tea, but if we can finish in 15 minutes and be back here at, say, 5 to 11, that would be great. Thank you.